All right, good afternoon or good morning, depending on where you are joining us from today. My name is Matt Kissling. I'm a partner in Thompson Hine's Labor and Employment and Government Contracts Practice Groups, and I would like to welcome you to today's webinar. This is the third in a series of webinars examining what the shift in presidential power could mean for the country. Today we'll be discussing President Trump's recent executive action that revoked the nearly 60-year-old Executive Order 11246 and the corresponding affirmative action compliance obligations for federal government contractors and subcontractors. We'll examine the key points of the Trump executive order, and we'll discuss what the EEO, affirmative action, and potential DEI compliance landscape may look like going forward for the contracting community. I'm joined here today by my co-presenter and colleague, Chip Purcell. Chip is a partner and practice group leader of Thompson Hine's Government Contracts Practice Group. Before we begin, I'd just like to take care of a few housekeeping items. First, today's program is being recorded, and we will send a link to you within the next few days after we wrap up the webinar today. This presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates, or Thompson Hine. The content should not be taken as advice, as the views expressed here are for informational purposes only. If you have any questions during the webinar, please feel free to use the question box located in the control panel on the right side of your screen. We'll answer as many of the questions as we can at the end of the webinar here today. CLE credit for today's webinar is pending. Please be sure to complete the verification of attendance survey. The link to the survey is posted in the chat. We'll also paste the link in the chat at the end of the program. I will announce the attendance tracking code at the end of the program here today. In the handout panel for the webinar, you can also download a copy of the PowerPoint slides that we'll be working through today, as well as copies of bios for both Chip, Purcell, and myself. Again, thank you for your interest. If you have any questions as we go along, please use the question box and we'll make every effort to respond to them before we wrap up today. So without further ado, we're going to be talking about three main topics here today. First, I'm going to provide a brief background of Executive Order 11246 and what the corresponding affirmative action compliance obligations were for government contractors. We'll then jump into a discussion of President Trump's Executive Order 14173 that was issued in mid-January and the revocation of affirmative action requirements. And then finally, we'll wrap up with a discussion of contract and compliance considerations in the post-Executive Order 11246 environment. So from a starting point, why are we all here today? So on January 21st of this year, President Trump signed Executive Order 14173, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This was part of a broader flurry of executive orders targeting affirmative action and DEI initiatives in the federal government and private industry. Those other executive orders included 14148, which was titled Initial Rescissions of Harmful Executive Orders and Actions, Executive Order 14151, Ending Radical and Wasteful Government DEI Programs and Preferencing, and Executive Order 14168, which was titled Defending Women from Gender Ideology, Extremism, and Fostering Biological Truth and Restoring Biological Truth to the federal government. Now, for our purposes here today, we're going to be focusing on 14173. And what it did is it formally revoked Executive Order 11246, as well as subsequent executive orders that supplemented or amended the original executive order. This action was effective immediately, but was subject to a 90-day grace period for existing federal contractors and subcontractors. And what it did at the end of the day was it eliminated one of the core authorities underlying affirmative action EEO compliance efforts in federal contracting. But let's start with the background. So what exactly did Executive Order 11246 do? It was originally signed by Lyndon B. Johnson on September 24th, 1965, so it was slated to celebrate its 60th anniversary this year. This occurred roughly 1 year after Title VII of the Civil Rights Act became law. And really the underlying intent of Executive Order 11246 was to extend and amplify the Title VII protections to the government contracting community. The executive order applied to prime federal contractors as well as subcontractors at any tier, as long as a contractor met a $10,000 contract threshold from the baseline perspective. And much like Title VII, the executive order prohibited employment discrimination based on race, color, religion, sex, and national origin. In more recent years, that was expanded to include sexual orientation and gender identity. And on top of anti-discrimination requirements, the executive order also required federal contractors and subs to engage in affirmative action activities for protected groups of employees, with specifically gender and race or ethnicity. Now, the specific activities required by the executive order did vary depending on whether you're on the supply and service side or on the construction side of the process. And the executive order applied both to prime contractors, the first-tier subcontractors, and potentially further down the subcontracting chain. And the organization that was charged with enforcement of the executive order, the Office of Federal Contract Compliance Programs, also has had issued guidance over the years that expanded the reach of the executive order's coverage, where it could potentially have applied to an entire organization, even if only one location or one division in a company did government-related work. And then under the Department of Labor's single entity test, it could have also applied across the family of companies to include parents, subsidiaries, and affiliates if all those entities together, according to the DOL, constituted a single entity. So the executive order's implementing regulations were found at various portions of 41 CFR Part 60. So Part 60-1 outlined the general requirements applicable to all contractors. Part 60-2 outlined and discussed the specific affirmative action plan requirements for supply and service contractors. Then similarly, Part 60-4 discussed the specific requirements for construction contractors. And again, all these regulations, as extensive as they were enacted pursuant to Executive Order 11246. We also found the executive order embedded in federal contracts themselves via the Federal Acquisition Regulation. There are really four core FAR provisions that apply to the executive order. That include 52.222-23, which address construction, affirmative action, -25, which address affirmative action compliance for the supply and service side, -26, which address equal opportunity more broadly, and again, -27, which was another provision that covered affirmative action compliance for construction. I'm going to briefly turn it over to Chip, and he's going to provide additional detail on how the FAR clauses operated in the contracts.
Thanks, Matt. So these are clauses that were enacted through a notice and comment period. I mean, it's been, I think I looked up the -26 clause and it was 1995. So they went through a notice and comment period where the public had a chance to comment on the proposed regulations that implement the executive order. And these are, I think for just about every contract I ever see, these are fundamental clauses that are included in the contract. So as of today, we'll talk about this a little bit more as we go forward. These are contract clauses that remain within contracts until your contracting officer, until the agency takes some sort of action. We'll talk about that a little bit more later on. Matt?
Okay. Thank you, Chip. So from a compliance perspective, what exactly did Executive Order 11246 require? So for all contracts and subcontracts, there was a mandatory equal opportunity clause that a covered party needed to include in their agreements, as well as ensure there was sufficient flow down to subcontractors down the chain. Compliance involves certain voluntary applicant and employee self-identification surveys, specifically for gender and the race and ethnicity categories defined for EEO 1 reporting purposes. And compliance requirements included workplace postings and policies, including the pay transparency non-discrimination provision that needed to be posted both on bulletin boards, on any company intranet, as well as included in company handbooks. For the supply and service side, requirements included the development of written affirmative action plans and programs, where an individual plan was required for each facility or location with at least 50 employees. And the one thing to note was that the written AAP requirement only applied if you held a single contract worth at least $50,000. And if you did, then you needed to have an individual plan for each location with 50 plus employees. If you had locations that had less than 50 employees, there were several options for how to incorporate those employees into an affirmative action plan. And this was an annual ongoing requirement, and tended to be one of the more heavy lifts from a compliance perspective under the executive order. Then finally, the executive order had certain record keeping and retention requirements related to hiring records, personnel records, affirmative action, compliance programs, things along those lines. And those record keeping obligations ranged anywhere from a 1 to 3 year retention period. So for the affirmative action plans themselves, there are really a number of key components that went into the process. Probably the largest component were the statistical analyses, where there were really 3 kind of core types of analyses they needed to perform on an annual basis. This include what we would typically call the job group and organizational analysis, where these are really reports on your employee demographics broken out by self-created job groups as well as by individual departments within a particular location. The job groups could either mirror your traditional EEO1 groups or classifications, or they could be more specific to the business depending on contractor preference. The second group of analyses, what we typically would call the availability and incumbency analysis. And these were really a comparison of your current workforce to projected labor availabilities in certain census areas. Or really the nuts and bolts of how you would put this analysis together is you would have to assign individual census code to each of your positions, and then use those census codes to calculate an estimated percentage of the time you look both externally and internally when filling roles, and then generating a report and analysis that projected the availability of both females and minority classes for each position within each of your job groups. And once you completed that exercise, the final analysis that was required were the underutilization and placement goal analyses. But these are really a determination of statistically significant shortfalls for protected gender and race groups, and then resulting placement goals. Again, this was comparing your current demographics against the projected labor availabilities based on the census codes. And if a shortfall for a particular group, generally exceeded 2 standard deviations, that was generally the threshold for determining statistical significance. And if that existed, that would generate a resulting placement goal for that job group and that protected classification. So what else did an affirmative action plan require? In the regulations, there were also certain self-assessment analyses that needed to be performed on an annual or scheduled basis. This included personnel activities, so hires, terminations, promotions, applicants. These were all, what we would traditionally call the adverse impact analyses. Really designed to determine, are any protected groups of employees being disparately impacted by the hiring process or the termination process. And from the government's perspective, if an adverse impact existed, to them this was potential evidence of actual discriminatory practices taking place. Another type of analysis that was required were analyses of compensation systems, otherwise known as pay equity audits. This was an area of renewed focus for the OFCCP in recent years, where as part of their audit process, they were starting to require contractors to submit documentary proof that you had actually undertaken a comprehensive analysis of your compensation systems. Again, this was something that was specifically required by the affirmative action regulations under the executive order. And finally, required analyses included, look at your selection, recruitment, and referral procedures. Again, designed to root out any potential disparate impacts affecting protected groups of applicants or employees. Other core requirements included development of action-oriented programs. So if you undertook the underutilization, placement goal, or adverse impact analyses, and there were areas of concern, as part of the affirmative action process required you to develop action-oriented programs designed to address those problem areas. So this could have included targeted outreach and recruitment activities for an underutilized group, instituting compensation adjustments or overhauling compensation policies and procedures. It could even have included updates to selection procedures, including at various processes or procedures at various stages of your individual selection process, whether it was employee testing or the interview process, things along those lines. And finally, a requirement included in developing internal audit and reporting procedures. And these procedures are really designed to keep contractors accountable for implementing and executing and keeping track of those action-oriented programs. So it was really designed to monitor the effectiveness of your AAP, including from an outreach and recruitment perspective, internal reporting, and employment activity. And again, it was designed to hold contractors accountable to make sure you were actually doing the things you said you were going to be doing. Now, on the construction side, the requirements under the executive order were a little bit different. So there, generally, there was no written affirmative action plan requirement. Instead, construction contractors and their subs, were expected to work towards certain utilization goals for minorities and women. Now, the female goals were on a nationwide basis, but the minority goals really depended on the geographic region where the construction contract work was being performed. And part and parcel with these utilization goals was the expectation that contractors would aspire towards achieving the representation in their workforce for females and minorities that was in line with whatever the specified goals were. Construction contractors were also responsible for notifying the Department of Labor of every subcontract awarded under a federal construction contract. And the OFCCP actually had a specific reporting portal for construction contractors to use to complete the reporting process. And finally, contractors and their subs were required to follow a 16-step process for complying with their affirmative action obligations in the executive order. These include specific requirements related to recruitment practices, training, implementation of EEO policies, analyzing personnel activity, as well as solicitations and contracts with subcontractors. And these are all areas that the OFCCP would delve into if they were to conduct a compliance evaluation. So that's a lot of discussion about what was required. What did the executive order not require? First and foremost, the executive order and its regulations and the Department of Labor were all very careful to say that contractors were not expected to set quotas. These were actually illegal under the executive order, as well as Title VII and other federal laws and the implementing regulations. They were very clear to say contractors were not supposed to and not expected to set quotas. Contractors weren't expected to hire less qualified or unqualified candidates. At the end of the day, they were still free to hire the best qualified candidate for the job. And this is part and parcel with the Trump administration's current viewpoint that companies should be making merit-based employment decisions based on qualifications, skills, and other tangible factors. And the executive order didn't require any sort of preferential treatment for any protected class. Now, the one exception I would say to that would be if the government came in and told you you needed to be giving preferential treatment to a particular group. But this was usually a situation where they had come in and conducted an audit, found areas of concern, and as part of a settlement process or resolution, imposed, whether specific promotion practice requirements or affirmative hiring requirements for a protected group. And finally, the executive order did not require contractors to ignore or forego merit in employment decision making. Again, this is consistent with the Trump administration's current viewpoint about how companies should be making employment decisions. And really, at the end of the day, what the overall purpose of the executive order and the affirmative action process was to enable contractors and encourage them to take steps to really achieve and promote as broad and diverse a pool of qualified candidates as possible, as well as ensure equal opportunity for all employees to advance and succeed within your organizations. And in practice, the placement goals that would be generated by an affirmative action plan were often used as really kind of a marker for how effective a particular contractor's efforts were in these areas. So from an enforcement perspective, I mentioned earlier that enforcing the executive order really fell on the Office of Federal Contract Compliance Programs. This is a sub-agency within the Department of Labor. It's really the DOL's version of the EEOC, but it had significant oversight over contractor compliance with the executive order, as well as other affirmative action laws and requirements. If you were covered by the executive order, you would have been subject to OFCCP compliance evaluations with selections made via their internal federal contractor selection system. Allegedly, that selection process was random, where they would identify targets using SAM.gov registration, procurement databases within the government, EEO1 filings, and VETS filings. And more recently, they would also use organizations who certify compliance through the OFCCP contractor portal. But while the selection process was allegedly random, the OFCCP was known to target specific industries on an annual basis. And if you were one of those unlucky contractors who was selected for audit, and you went through the audit process, that likely meant you were on OFCCP's radar and you could expect a follow-up audit in anywhere from a 2 to 5 year period. Most evaluations from the OFCCP began with what they call the desk audit, where they would send you a letter demanding 30 categories of documents to prove affirmative action EEO compliance, and they would give you 30 days to send everything in. And really, these categories were all encompassing. They included copies of your written affirmative action plans for the location at issue, documentation of your personnel and employee level practices and compensation data. I mentioned earlier, on the compensation front, they would demand proof that you had undertaken, a compensation review or a pay equity audit. And it also would include, sending in documentation of your outreach efforts and your self-assessment of how you were doing from an outreach and recruitment perspective. While desk audits were the most common form, they could also lead to an on-site audit by the OFCCP, where compliance officers would actually come on location to a facility, where they would typically conduct employee interviews and request and review additional forms of documentation as part of their investigative process. So what if OFCCP found problems? What were the remedies at their disposal? So the most common form was the conciliation agreement, where it's basically a settlement agreement entered into between a contractor and the OFCCP, where you would have to agree to do certain things, take certain steps, and most often agree to progress reporting and continued monitoring for a defined period. In certain situations, the OFCCP could also pursue enforcement actions before the DOL's Office of Administrative Law Judges. And as part of any sort of resolution process, we would see OFCCP impose affirmative hiring requirements to correct what they viewed as hiring discrimination. It could include payment of back wages and benefits to impacted groups of employees or applicants. They could require policy modifications and training. And in the most serious cases, OFCCP had the authority to pursue contract cancellation or debarment for noncompliance with the executive order. Again, that was typically reserved for the most serious of situations, but it was a remedy that we had seen OFCCP pursue. So that was all the before times. So let's talk about what happened on January 21st of this year with Executive Order 14173. So this was signed by President Trump on the 21st, and from an overall perspective, it proclaimed the administration's belief that despite the existence of federal anti-discrimination laws, that the federal government and corporations across the country have adopted and actively used dangerous, demeaning, and immoral race and sex-based preferences under the guise of DEI initiatives. The executive order expresses the view that these types of initiatives diminish the importance of individual merit, aptitude, hard work, and determination. And going along with those policy statements, the executive order formally revoked 11246 with the stated justification that the federal contracting process would be streamlined and that contractors will instead be required to comply with civil rights laws. I mentioned at the outset that there is a bit of a grace period for contractors and their subs who wish to voluntarily continue compliance with 11246, and that voluntary compliance window closes. There is in effect for 90 days and is slated to close on April 21st of 2025. So it's basically the government saying for the next 90 days, if you want to continue complying with the old executive order, you can, but after that point, any further compliance activity needs to cease. With that said, the executive order did direct the OFCCP to immediately cease from any efforts or programs that are promoting diversity, which they did not define what they specifically mean by diversity. Directed OFCCP to cease from holding contractors and their subs responsible for taking affirmative action. And they directed the OFCCP to cease from allowing or encouraging the contractor community to engage in workforce balancing based on race, color, sex, sexual preference, religion, or national origin. So in other words, it basically ordered a full stop to the OFCCP on any sort of compliance activity related to Executive Order 11246. President Trump's order also directed all federal agency heads to include 2 new clauses in future contracts and grant awards. The first clause will require a contractor or grant recipient to agree that your compliance in all respects with applicable federal anti-discrimination laws is material to the government's payment decisions. And I didn't include in this quote, but this particular clause in the executive order also makes specific reference to the False Claims Act. And so that's teeing up the potential for False Claims Act claims by the government if a contractor certifies that it's in compliance with anti-discrimination laws and the government comes in and finds out that was not the case. And the second new clause that's going to be going into contracts is a mandatory certification that a contractor or grant recipient does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. And again, the executive order does not define what it considers to be DEI or provide examples of the types of programs it would view as potentially violating federal anti-discrimination laws. The executive order also required the OMB director to review and revise all government processes, directives, and guidance, including those for contracting and procurement, to remove references to DEI, as well as terminate all diversity, equity, and similar programs or requirements. Then finally, the executive order directed the federal government and took the position that it's claiming to terminate illegal discrimination in the federal government by revoking a number of different Clinton and Obama era executive orders. And really the directive to federal agencies was to terminate all DEI, internal DEI programs and initiatives. And I'm sure you've all seen in the news that government agencies have been doing that over the last couple of weeks and have been putting the majority of DEI personnel on paid leave or removing them from government employment. And from the private sector, the non-contracting sector, the executive order requires the Attorney General to provide recommendations within 120 days for enforcing federal civil rights laws in a manner to, quote, encourage the private sector to end illegal discrimination and preferences, including DEI. The recommendations provided by the AG must include a strategic enforcement plan against the private sector, as well as potential regulatory action and guidance. And also will need to include identifying potential civil compliance investigations against large corporations and associations that, at least from the government's perspective, may be continuing to have, potentially unlawful DEI programs in place. So I mentioned before that this executive order, directed the OFCCP to cease any enforcement activity under 11246. And so following on the coattails of this order, on January 24th of 2025, the acting Secretary of Labor issued an order 03-2025. What this did is it directed DOL agencies to immediately cease and desist all investigative and enforcement activity under the now revoked executive order. This applied to all pending cases, conciliation agreements, investigations, complaints, and other enforcement or investigative activity. Required formal notice to impacted parties by January 31st of 2025 that any executive order 11246 component has been closed. So if you are with an organization that was undergoing a current OFCCP audit, you should have received a letter from your compliance officer by January 31st notifying you that the executive order components of that audit have been administratively closed. And the Secretary's order also required the OFCCP to temporarily suspend any separate activities related to compliance under Section 503 of the Rehabilitation Act or under VEVRA. So that's what the OFCCP has done. They've basically gone full stop on their compliance and enforcement activity. Where does the EEOC stand on this process? So on January 21st of 2025, President Trump named Commissioner Andrea Lucas as acting chair of the EEOC. Commissioner Lucas was an appointee to the commission during Trump's first term and had remained in office during the Biden administration. And from a priority perspective, Commissioner Lucas has identified several key areas that she intends to focus on. First is rooting out unlawful DEI motivated race and sex discrimination. Second is remedying other areas that have been historically under-enforced. She doesn't provide any specifics into that as to what that may include. Another priority is defending the biological and binary reality of sex and related rights, including women's rights to single-sex spaces. I'll note that this, to a certain degree, is actually contrary to a formal guidance that the EEOC as a commission has issued related to transgender rights in the workplace. But it is Commissioner Lucas's stated priority for how she's going to approach her time as chair. Then finally, one of her priorities is to protect American workers from anti-American national origin discrimination. So what about the EEOC itself? So as you may have seen on January 28th, the president announced that he had fired Commissioner Charlotte Burrows, who was the former chair, as well as Jocelyn Samuels. And then the result of this is that it only leaves two commissioners on the EEOC, which actually deprives them of the quorum required to enact or rescind formal guidance on anti-discrimination laws. So at least for now, Commissioner Lucas's priorities are, to a large degree aspirational. She does not actually have the authority by herself to overturn, current formal EEOC guidelines or enforcement procedures. She would need a quorum of the commission in order to do so. But from the EEOC's perspective, they've issued a statement called the State of the EEOC, where they describe Executive Order 14173 as one of several executive orders that they consider to be restoring even-handed civil rights enforcement that combat serious patterns of discrimination and harassment that have gone unchecked for too long. So pretty good indication that from the EEOC's perspective going forward, they're really going to be targeting DEI initiatives and or potential preferences in workplace practices. Okay, so that's all about what the executive order from President Trump was about and what it did. And so the question I'm sure everyone is asking is, what happens next? As with anything, there is a large degree of uncertainty and open questions about, Executive Order 14173 and how it's going to be applied and what specifically the government is going to do. That really starts with a number of key undefined terms in the order itself. Conspicuously absent from the order is any definition of what the government considers to be DEI or DEIA programs, as well as what they would consider to be illegal DEI and DEIA policies. Other things that aren't defined are what the government considers to be equity and equitable decision-making, which are additional areas that, according to the executive order, the government is taking issue with and potentially focusing on. Another open question is, how is this going to interact with other existing laws out there? So good starting point would be, from a compensation perspective, how's this going to interact with pay equity considerations and obligations under Title VII and the Equal Pay Act? The president cannot revoke or rescind congressionally enacted law through an executive order. He certainly can't overturn Title VII or the Equal Pay Act and the corresponding requirements for companies to ensure equal pay for equal work and prevent discrimination and compensation. The other question is, how is it going to interact with other affirmative action obligations under federal statutes or state laws? So a number of states do have their own affirmative action requirements for companies that do business with a state or local agency. So the big question mark is, how is the administration going to treat those state level contracting requirements? And again, while OFCCP has suspended its investigations under Section 503 in VEVRA, again, those two laws themselves, were passed by Congress and impose separate standalone affirmative action requirements for individuals with disabilities and protected veterans. And the OFCCP has come out and said those two laws, from their perspective, aren't impacted by this executive order. But it remains to be seen how aggressive the agency is going to be from an enforcement perspective. And finally, there's a big question as to what exactly are the limits of executive power. We've all seen in the news, this is a really hot button topic these days, and to a large degree, President Trump's, revocation of Executive Order 11246 and his attempts to regulate the contracting community is based on the procurement process and the government contracting process. If you remember, a couple of years ago, President Biden attempted to rely on that same authority to impose COVID-19 vaccination and testing requirements on government contractors. His attempts to do so were found to be in excess of his power over the procurement process, and the courts found those that his attempts to impose these requirements to be unlawful, and they blocked them. So it remains to be seen whether those similar arguments will be applied to challenge what President Trump is trying to do here. And we've actually seen at least one legal challenge be filed against Executive Order 14173, where on February 3rd, the city of Baltimore and several industry associations and organizations filed a lawsuit in Maryland federal court, where, amongst other things, they allege that the provisions in 14173 that impacted federal contractors violate both the First Amendment and the separations of powers. Or from a First Amendment perspective, the argument is that corporate DEI initiatives are protected speech under the First Amendment, and so the president cannot deprive companies of their First Amendment rights to speech with respect to DEI initiatives. And from the separation of powers perspective, the argument raised was that Congress is the one that has the power of the purse, and so can the Trump administration really require those DEI certifications and contracts as a condition of doing business with the government and using government funds. The lawsuit also alleges that the provisions targeting the private sector are unconstitutionally vague and, like the contractor side of the coin, violate the First Amendment. They specifically call out that the executive order fails to define a number of material terms, including DEI and illegal DEI programs or policies, with the risk that the companies are really going to be left in the dark and are going to have to play a guessing game as to what may or may not be deemed unlawful by the administration. And so the lawsuit, it's currently pending. It is asking the court to declare the executive order unconstitutional and seeks both preliminary and permanent injunctive relief. And so, at least for now, 14173 is in effect, but it is subject to legal challenge, and will certainly keep everyone updated as further developments come out of the District of Maryland. So for now, what is no longer required from a compliance perspective? So from a high level perspective, you're no longer required to comply with Executive Order 11246 or the implementing regulations. So what does this remove? This removes the requirement to prepare written affirmative action plans for gender, race, or ethnicity, removes the requirement to engage in targeted outreach or recruitment and furtherance of placement goals identified in the AAPs, removes the obligation to conduct internal tracking and assessment of outreach and recruitment activity, no longer required to engage in scheduled evaluations and analyses of hiring, termination, promotion, or applicant activity. Similarly, you're not required to, at least by regulations of the executive order, to undergo pay equity reviews or other evaluations of compensation systems. And then finally, it relieves contractors from certain policy and poster requirements. And that would include the pay transparency non-discrimination provision. I mentioned earlier that there is a 90-day grace period. So for those out there who wish to continue to voluntarily comply for the next 90 days, or at this point close to 60 days, you are permitted to do so. But from an enforcement perspective, the OFCCP is not going to hold contractors accountable one way or another at this point. So on the construction side, what's no longer required? Those utilization goals I mentioned for females and minorities, those are no longer required, a required part of doing business, but construction business with the government. Similarly, you're relieved of flow down requirements of the 11246 clauses to subcontracts, and as well as the subcontract award reporting requirements to the OFCCP. And finally, you're not required to undertake the 16-step affirmative action compliance process under Part 60-4 of the 41 CFR for construction contractors. So what is still required? So let's talk about Section 503. So I mentioned before that the executive order does not impact compliance requirements under Section 503. What this does is it requires EEO and affirmative action compliance programs for individuals, qualified individuals with disabilities. And this includes preparing an annual written affirmative action plan if a contractor has a covered contract or subcontract worth at least $50,000. So what are the specifics of the 503 requirements? Again, prepare an annual AAP for individuals with disabilities for each location with at least 50 employees. As part of the AAP process at a location, establish a 7% utilization goal for individuals with disabilities within each job group at a location. From a data perspective, you're still required to solicit pre and post offer applicant self-identification data for disability status using the government approved form. And then for your current workforce, you're also required to survey your current employees every 5 years for disability related self-identification data. And at least at one point during that 5-year period, you need to remind employees that they can update their self-ID data at any time. There are also specific applicant and hiring data tracking requirements that remain on the books for individuals with disabilities. And while the outreach and recruitment for race and gender have gone away, there are still similar requirements on the books for qualified disabled candidates. And importantly, you're still expected to document and assess all activity that you undertake. Then finally, as part of your compliance programs, you're still required to conduct self-audits of your employment activity, job descriptions, your physical and mental qualifications, your training and promotion opportunities, and your physical facilities. And these are all designed to ensure that, qualified individuals with disabilities are given equal opportunities, for employment, advancement, promotion, and compensation. And the question to ask ourselves, is from a job description and physical mental qualification perspective, how accurate and how confident are we that what we have on paper is accurate? Because this could have broader implications, given the Trump administration's focus on merit-based hiring and employment practices. So having accurate job descriptions and accurate qualification requirements are going to go a long way to be, showing that you're being able to prove, that you are making employment decisions based on merit and qualifications. And kind of going along with the self-audit process, it's also recommended, that you take a look at your career pages and your websites. Are they compliant with Section 503 and the Americans with Disabilities Act for individuals who may need a reasonable accommodation to apply for a job or to view your website? So the same goes with VEVRA. So the executive order does not impact, compliance requirements for protected veterans under VEVRA. Or much like Section 503, VEVRA requires affirmative action and EEO programs for individuals who fall within the protected veteran categories. And these apply if a contractor has a covered contract or subcontract that's worth at least $150,000. And if you're covered, you're also required to file annual VETS 4212 reports with the Department of Labor. And the requirements under VEVRA are similar to Section 503, where again you need to have the written annual affirmative action plans. And while there's no utilization goal for protected veterans, VEVRA does establish an annual hiring benchmark for protected veterans at each location. That's currently 5.2%, which is reflective of the current percentage of protected veterans in the civilian labor force. Much like 503, you're required to solicit pre and post offer applicant information for protected veteran status. And there are also those specific applicant and hiring data tracking requirements for protected veterans. And then again, like 503, there's, you have the obligation to engage in targeted outreach and recruitment, and document and assess all activity. Interestingly enough, President Trump's executive order expressly states that it does not apply to veteran-related affirmative action or EEO requirements. And so that's implicitly saying we acknowledge that VEVRA is still the law of the land and that contractors should still be undertaking these activities. So I made a couple references to data tracking. So while all the various data tracking points under the Executive Order 11246 are no longer in effect, there are specific things you need to be looking at and tracking under 503 and VEVRA. And this is specifically tailored to applications and hires, where on an annual basis, you need to conduct an analysis of the total number of applicants that you've received for open positions, the total number of applicants who self-identified as disabled or as protected veterans, the total number of job openings that you had at a particular location, the total number of positions filled, whether externally or internally, the total number of applicants that were hired, and then the total number of hireds who self-identify as disabled or as protected veterans. And so these are all things that we should be tracking and incorporating into our annual affirmative action plans for veterans and individuals with disabilities. And again, I mentioned before, the big question mark is how exactly is the OFCCP going to enforce 503 and VEVRIG going forward? While they've currently paused that enforcement activity, one possibility would be is we could see a return to what the OFCCP had previously called focused reviews from an enforcement perspective, which were things that were rolled out during the first Trump administration, really specifically targeted affirmative action compliance for veterans and individuals with disabilities. So that remains to be seen, but that is one possibility, is that we'll see focused reviews come back in the near future. So what are our other compliance things that we still need to be thinking about from a compliance perspective, notwithstanding President Trump's order? So EEO1 reporting. This is a process that's authorized by Title VII for private employers with 100+ employees. So even if you're a federal contractor, if you have at least 100 employees, you're still required by law to engage in EEO1 reporting. We're still waiting on the process to start for this year, but it is something that, at least for now, is still on the books. Same goes for state reporting requirements. So if you have operations or employees in California, Illinois, or Massachusetts, I'm sure you're aware that there are state-specific EEO1 or pay data reporting requirements that are in effect. California has an annual pay data reporting requirement for this year. All reports are due on May 14th. Massachusetts requires employers with at least 100 folks in the state of Massachusetts to file copies of EEO1 reports by February 1st of each year. Then Illinois has certain biannual pay and wage data reporting requirements for companies that do business in the state of Illinois. I mentioned previously, another thing we still need to be thinking about is equal pay compliance, and President Trump's executive order, despite targeting equity programs, really cannot supersede federal laws that require that very same thing from a compensation or pay perspective. So again, that would include the Equal Pay Act, as well as Title VII's prohibition on compensation discrimination. What about state or local requirements? So this is an area we would not be surprised to see increasing movement, in the next 4 years, is implementation of state or local affirmative action requirements as a condition of doing business with the state or local government. So, in prior years, if you were, covered by one of these laws, there was a decent chance that your obligations were satisfied by, preparing your affirmative action plans under Executive Order 11246. Since the federal requirement has gone away, you may now need to turn your focus on the specific state or local requirements and adopt and prepare affirmative action plans that are tailored specifically to the state or local requirements. What I can tell you is that to varying degrees, in the states that currently have some form of affirmative action plan on the book, those states include both blue and red leading states. So that would be Ohio, Kentucky, Minnesota, California, and New Jersey are all states that have some form of affirmative action compliance program, in effect for state contracts. And from a local perspective, I'm aware of at least 3 cities, that include Cincinnati, Ohio, Madison, Wisconsin, and Bloomington, Indiana, that have their own local affirmative action compliance requirements out there. Where again, those are programs you need to make sure you're putting into place if you're doing business with one of those local governments. So, talked a lot about what obligations remain and are left untouched by President Trump's executive order. I just want to quickly shift to what are our new obligations under 14173. So I mentioned at the beginning that there are going to be 2 new contract certifications that come into play. The first is a certification, an agreement that compliance in all respects with anti-discrimination laws is material to the government's payment decisions. And there's specific reference to the False Claims Act when you're making this certification. So the big question to ask is, as we sit here today, who is comfortable making this type of a certification in a government contract? And this really stresses the importance of making as informed of a certification as possible. And so, things to consider is, should we repurpose our existing compliance programs, and really pivot them, and use them in a way where we can ensure that we're making as informed of a certification as possible, and we're telling the government that we are in compliance in all respects with federal anti-discrimination laws. So things to consider is, should we continue evaluating our personnel activity, conducting adverse impact analyses under attorney-client privilege, because outside of the government contracting space, what these analyses are designed to detect are disparate impact discrimination. So problems that may exist that you don't even know about until you analyze your employment activity. And who else loves to jump all over disparate impact claims is the EEOC. And so that could be a factor weighing in favor of continuing to voluntarily analyze your personnel activity on an annual basis, and potentially do it all under attorney-client privilege. Same goes with conducting pay equity evaluations. Both from a federal perspective as well as the growing number of state equal pay laws and state pay transparency laws. If your pay information is going out into the public domain, how comfortable are you with your current compensation programs? And are there any potential areas of concern that need to be analyzed and addressed? And so one thing to consider is, conducting fully privileged pay equity evaluations. And that's one of the advantages of the federal contracting affirmative action requirements going away, is you're no longer required to maintain non-privileged documentation of one of these audits to give to the Department of Labor. At least at this point, you would now be permitted to conduct this fully under privilege, and then address any problem areas that are identified accordingly. The same goes with, should we continue evaluating our internal programs, policies, and practices to ensure equal opportunity? Again, are all of our employment practices available to everyone across the company, and is there no preference given to any sort of protected classes of employees? And the same goes with job descriptions, evaluation procedures, hiring criteria, and things along those lines. How comfortable are we to say that these are being applied equally to everybody? So the other thing to think about is we also have to certify that we don't have any programs promoting DEI that would potentially violate federal anti-discrimination laws. So there, some key considerations here are, first, for existing DEI programs or initiatives, do they contain anything that could be deemed an unlawful preference under Executive Order 14173? And so it's really undertaking a review of what you're currently doing and seeing, are there any potential red flags that for the government, and what steps do we need to take to address them. If you have affinity groups or employee resource groups within your company, can we take steps to ensure that participation is open to all employees and that this is clearly communicated to, again, make clear we're not excluding anybody from these programs. Everyone who's interested, is free to participate. But it's also looking at, how do these groups operate day to day? Are any groups of employees being inadvertently excluded or underrepresented in an organization? And if the answer is yes, is there a particular reason why? And is there a way we can address that potential issue? Another question asks, are DEI achievements or affirmative action achievements a factor or something that's considered in performance or compensation reviews, particularly for management level personnel? If the answer is yes, then maybe something that you would need to consider removing from the performance or compensation review process. Similarly, is DEI participation or leadership something that's considered in promotion or advancement decisions within the organization? Again, if the answer is yes, that could run the risk of the government, considering that to be providing, some sort of an unlawful preference or favoring one group of employees over another. Another question to think about are hiring or recruiting practices, including outreach efforts, at risk of being construed as creating one of those preferences based on a protected characteristic. Again, I think the goal here is to cast the recruitment and outreach web as broad as possible to capture as many qualified employees and candidates for employment as possible. So if you're focusing on particular groups under your old affirmative action obligations, what are steps we can take to expand that web to other groups of candidates and other interest groups? And then, do we offer any sort of internships, co-ops, or scholarships that promote preferences based on a protected characteristic. As you can imagine, this is likely going to be an area that government agencies are going to be focusing on, from a compliance perspective when they go in and look at companies' DEI programs. Are companies giving specific benefits to one protected group of employees over another? If the answer is yes, that could be problematic from the administration's perspective. Other things to think about, is there anything that we're putting out in public, that could be problematic, that would be easy fodder for the government to focus in on. So, external company reports or publications, what language is included in there? Is there anything that states company preferences? So this could include proxy statements that are getting filed with the SEC, any annual reports or other investor publications that are published or posted on your website, that oftentimes may include discussions of how the company, considers or identifies board candidates, ESG reports, and finally, websites, career, pages, job postings. These are all things that, be wise to give another look to see, is there any language on there that needs to be updated or that could prove problematic going forward under the current administration. So I've talked a lot about, the kind of the EEO and the employment compliance front. I'm going to turn it over to Chip to, talk about from a contractor perspective, what are the things we should be thinking about going forward.
Thanks, Matt. In the couple of minutes we've got left, I'm just going to hit a couple of points for contractors to consider in this sort of period of time where there are these changes that Matt has been discussing. First and foremost, very fundamentally, is review and understand what the clauses are that are in your contract. That obviously would include the clauses that Matt has talked about today that are the subject of the recent executive order, as well as the clauses that relate to affirmative action related to veterans and workers with disabilities that may fall outside the scope of that executive order. Just to understand, what are you subject to? What are clauses that, from the executive order's perspective, may no longer be enforceable? In addition to that, it's always good to understand what the clauses are in your contract that may provide you rights and remedies with respect to actions or inactions that the agency may take administering your contract. There's the changes clause, there's the government delay of work clause, which says that the contractor has a right to seek a cost adjustment due to the action or inaction by a contracting officer in his or her administrative capacity. So it's as important as it is to understand what are the clauses that are impacted by this executive order, understanding what your rights are with respect to how the government's going to administer this contract or your contracts, in this sort of period of transition and change. And as part of that too, if you've got an affirmative requirement to notice the government of some impact that you are incurring as a result of the way the government is administering the contract, make sure you understand what the timeliness is of any kind of notice requirements. So second, monitor agency activities, and I would say that applies sort of on the micro and the macro level. On the macro level, as we talked about, there are these clauses, the equal opportunity clause being one of them, that are impacted by this recent executive order. Under the normal course of things, you would expect that the FAR Council would issue some sort of a notice in the Federal Register saying, as a result of this executive order, the following clauses are going to be repealed. And then that would follow with a contracting officer's modification to a contract to remove or delete those clauses. That's presumably what will happen. Agencies may issue some sort of direction in the interim speaking to these clauses and how they're going to be viewed or enforced by the agency. So it's important to keep your eyes out for that. And then with respect to the clauses that this most recent executive order calls out that are supposed to be implemented, again, the same process would apply. Presumably the FAR Council will issue a notice of a proposed rule and the opportunity for folks to comment on these proposed regulations implementing elements of the executive order. It may be the opportunity for people to ask questions about and clarify some of the terms that Matt talked about. So it's important to keep your eye out for that. Again, those would appear in the Federal Register, and presumably there would be an opportunity for folks to comment on them and for the agency to provide feedback. And that second sub-bullet, for the folks you have that interface with a government customer, just make sure that they're attuned to these issues and they can, they are communicating the way they should be communicating. And if they are receiving information, that they're alerting the folks in charge about what they're hearing from their contracting counterparts. And then the last bullet, tracking agency actions, to the extent that the things that we're talking about today impact your cost of performance, the schedule to perform, those are impacts that you should be able to track, or you should track. So you can potentially seek some sort of a remedy through an equitable adjustment with the contracting agency. So ideally, you're finding ways to record those impacts, whether they're labor hours or additional costs, whatever they may be. And it may be in the short term there are not any, but it could be as we go through this period of transition that there are. So it's important to be able to track those things and quantify them. So when you're in discussions with the agencies about what these impacts are, you've got a way to talk about them. So, some just always fundamental from my perspective to be communicating with the agency, hopefully in writing, but if you're talking with the agency, recording those conversations and sort of sending them back to the agency so you can track them as the agency's figuring out what these impacts are going to be. Matt?
Thank you, Chip. So with that, our webinar today is concluded. Our next installment in the series will continue on February 18th at 2:00 p.m. And that will discuss the Trump administration's anticipated approach to environmental laws and regulations. So thank you again for attending here today, and I hope you enjoy the rest of your day.